So the Ninth Circuit just remanded the California assault weapons ban case Miller v. Bonta back down to Judge Benitez. So let's talk about this. But real quick before we jump into this video, if you agree that the California ban on so-called assault weapons violates the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, the Ninth Circuit just remanded the Miller v. Bonta California ban on so-called assault weapons back down to the District Court and District Court Judge Roger T. Benitez for reconsideration of the case in light of New York State Rifle and Pistol Association v. Bruin. This is an effort by the Ninth Circuit to once again punt this case and to stall the case out for as long as possible now that the Supreme Court has rejected the prior decisions of the Ninth Circuit. So in this video, I want to talk about what happens now that this case has been remanded back down to Judge Benitez, and what are some potential good opportunities that are available to us now that the case is back in the hands of Judge Benitez. Now, for those who are not aware, Miller v. Bonta is a challenge to the state of California's ban on so-called assault weapons. The Miller case was originally heard in the Southern District of California before Roger T. Benitez, or St. Benitez as he's known in the state of California. In the original review of this case, Judge Benitez found that this case was an average case about average guns used in average ways for average purposes. In reaching his decision, Judge Benitez used a standard review that was just affirmed by the Supreme Court in the Bruin decision. He looked at the text of the Second Amendment and the history of our nation to determine if the state of California's ban on these types of firearms is indeed constitutional. He determined on review that this ban was not in line with the text or history of the Second Amendment. In fact, in reaching his original decision, he stated, "A ban on modern rifles has no historical pedigree. Prior to the 1990s, there was no national history of banning weapons because they were equipped with furniture like pistol grips, collapsible stocks, flash hiders, flare launchers, or barrel shrouds. In fact, prior to the California 1989 ban on so-called assault weapons were lawfully manufactured, acquired, and possessed throughout the entire United States." After he struck down the California ban on so-called assault weapons, he did issue a temporary stay on his own order that was set to sunset and terminate after 30 days. Well, of course, the state of California did appeal the decision up to the Ninth Circuit, and also they sought that emergency stay and ultimately were granted both of those. Then the Miller case was put on hold because of a backlog of cases that were waiting on the Supreme Court to rule in New York State Rifle and Pistol Association v. Bruin. However, recently the Supreme Court, as many of you know, did issue that ruling in Bruin, and they struck down the Ninth Circuit's use of the two-step approach and other circuit courts as well who use the two-step approach or the two-pronged approach. And in that decision, Bruin, they affirmed that text as informed by history is the correct type of constitutional analysis when you're dealing with the Second Amendment. In reaction to all of that, FPC, through outside counsel, filed for a motion to lift the Ninth Circuit stay on the Benitez ruling and to fast-track review of the case at the Ninth Circuit level. Well, the state of California opposed that motion to lift the stay, and they also pushed for the Ninth Circuit to vacate the Judge Benitez order, that original ruling, and to remand the case back down to Judge Benitez for him to review the case once again and to decide the case once again in light of Bruin. This fact shows how weak the Bruin decision really made these types of bans, and typically the state of California has no issue letting these cases run through the Ninth Circuit because in the past they had the balancing of interest, the two-step approach to lean on, and also the Ninth Circuit simply would always defer to the state of California's public interest arguments. But now that can no longer happen. So now they feel safer just stalling the case out as long as possible instead of letting it sit at the Ninth Circuit or proceed forward at the Ninth Circuit, because they know ultimately when these cases are decided, the Ninth Circuit's hands are tied and they must rule against the state of California. So the only card they have left is to get the case remanded back down to the same judge who already ruled against them using the same type of analysis, which is text as informed by history. So it was up in the air what the Ninth Circuit would actually do, but we did get an order last night from the Ninth Circuit that said that they are going to vacate the Judge Benitez original ruling and to remand it back down to him for reconsideration in light of Bruin. The order from the court reads that Silverman, Nguyen, and R. Nelson, the circuit court judges, appellant's motion to vacate the judgment, challenge in this appeal, and to remand for further proceedings is granted. The district court's June 4th, 2021 order and judgment are vacated. This case is remanded to the district court for further proceedings consistent with the United States Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin. All other pending motions are denied as moot, and the final order is vacated and remanded. So this case is now heading back down to Judge Benitez for him to reconsider the case in light of Bruin. the likelihood is that Judge Benitez will in fact rule against the state of California once again. He already found in the original case that there was no textual or historical basis for this type of ban in the state of California. And now with clearer guidance from the actual Supreme Court, he will not suddenly just decide to flip his decision. If anything, his decision is going to be even more resolute. If anything, he has been completely validated by the Supreme Court. Many in the media were going after Judge Benitez as a radical, and many of the judges, even in the Ninth Circuit, said his rulings were not in line with Supreme Court precedent. However, he was just validated by the Supreme Court, and now he gets to stick it to the state of California and all the Ninth Circuit judges who said he got it wrong the first time in this case and other cases as well. Now, some of you may be thinking, well, great. Now we have to wait another year for a case like this to be resolved, for the Miller case to make its way through the trial process once again, and for Judge Benitez to issue his final ruling in Miller because it's going to have to restart, new supplemental briefings, all of that. That is not necessarily true. Judge Benitez can fast track this case if he wants. He can expedite briefings. And also, in the meantime, I have no doubt that a TRO and a motion for a preliminary injunction will be requested by FPC. A temporary restraining order is a protection mechanism that a party can seek in a case like this. The standard to be granted a TRO is similar to the standard for obtaining a preliminary injunction, with the primary difference being the duration of time that a TRO is in place versus a preliminary injunction. TROs are granted in situations where there is an emergency, where significant harm will come if the court does not decide to halt the state's conduct until a full hearing on a preliminary injunction can take place. While in contrast, a preliminary injunction, if granted, remains in force through the duration of the entire case. So the main difference between a TRO and a preliminary injunction is the length of time that the protection is granted and the situations in which they are granted. But the ultimate goals of both of those is to get relief from the court before the case is fully resolved by a trial. So it's a type of relief that you can get without having to go through the entire process. I would say now more than ever, it's likely that Judge Benitez will grant a preliminary injunction against the state of California and their ban on so-called assault weapons. Benitez has proven in the past that he is not afraid to do the right thing when it comes to the Second Amendment, and even more so, now he has the Supreme Court's decision to back his own decisions. So right now, the battle, in my opinion, will be between a TRO and a preliminary injunction and whether or not Judge Benitez will grant one or not. Now, one other important thing that I want you guys to keep in mind is that even if Judge Benitez grants a TRO or a preliminary injunction, the state of California still can appeal that very decision. This mechanism is often referred to as an interlocutory appeal. The best way to understand what an interlocutory appeal is simply it's an appeal on an order by a court that isn't the final judgment of a case, but instead of something like a motion for something that's going to significantly impact a case like a preliminary injunction. So there is some relief that Judge Benitez can give sooner rather than later, but even if that happens, the state of California still has the option to appeal that up to the Ninth Circuit. And sooner, maybe rather than later, this case will ultimately lead its way back up to the Ninth Circuit. And the Ninth Circuit, once again, will have to decide what they want to do. So again, it's not the best case scenario that the Ninth Circuit remanded this case back down to Judge Benitez, but we do have the benefit that it is back in the hands of Judge Benitez. And his track record shows, even in this own case, that he will rule in favor of the Second Amendment, and he agrees that texts as informed by history do not validate these types of bans. These types of bans are unconstitutional, and I have no doubt that he will rule similar and probably will be even more adamant in his ruling, and maybe will even have stronger words for the state of California now because of the Bruin decision by the Supreme Court. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built by Armed Scholars, and this nation will be maintained by Armed Scholars.